Hi, and welcome back to this course on international law and organization. This is a lecture for week 4 about non-state actors in international law and organization, and first and foremost about multinational corporations and non-governmental organizations. Now, when we think of actors in international law, we tend to think mostly about states, nation states. And this makes sense for all the reasons that we looked at last week, because nation states are the center, they're the foundation of the Westphalian system. There are, however, a lot of other actors in international law, and the importance of these non-state actors has been slowly increasing over time. Now, you might be forgiven for assuming that this means that this is a new trend in international law, that there really weren't non-state actors in the past, and it really takes off after the Cold War. But if anything, it's really the revival of an old phenomenon. In the Middle Ages, for example, religious orders that operated independently of states spanned not only Europe but the entire globe. They could have tremendous wealth and power, prestige. Jesuit priests were often found in the courts of Qing dynasty emperors and might wield more influence than delegations from actual European countries. Independent religious military orders like the Knights Templar or the Teutonic Order could field powerful armies and capture territory, defeat countries, states in battle, and the Teutonic Order is essentially responsible for founding the country of Prussia. So, non-state actors also played a particularly powerful role in creating the horrors of colonialism, with chartered companies like the British and Dutch East India Companies wielding many of the legal powers of a state. So when we examine non-state actors like non-governmental organizations or multinational corporations in international law today, we can see glimmers and remember that while the Westphalian supremacy of the state has long been dominant, at least in the West, this dominance has always been contested by non-state actors. Non-governmental organizations, while most are tiny, a handful of large non-governmental organizations like BRAC, an international development organization based in Bangladesh, have revenues in the hundreds of millions of dollars and their staff number in the tens of thousands. This puts them on par with smaller nation states. Well, it's primarily states that represented in intergovernmental organizations. We'll talk about next week, organizations like the United Nations. Some NGOs influence these institutions through advice, observer status, and sometimes a formally equal seat at the table to those of nation states. For example, a number of NGOs, I think over 1,000 NGOs, that worked together to ban landmines got a formal seat at the table when the international treaty to ban landmines was negotiated. NGOs also play a particularly important role when it comes to monitoring compliance with international laws, rules, and norms. When a country where a country or organization violates international rules that limit torture, protect the environment, or ban chemical weapons, or preserve historic sites, it's often an international NGO such as Amnesty International or Greenpeace that bring these violations to the attention of states, to the attention of intergovernmental organizations, and the world at large. Now I'm going to turn to multinational corporations. These are as large and powerful as some of the biggest non-governmental organizations are. They pale in comparison to the most powerful non-state actors in international law, which are undoubtedly multinational corporations. These are also known as MNCs or MNEs, as in multinational enterprises. They also get other names. While MNCs is probably the way you'll see it written in the literature, I'll stick with the term multinational because I feel like it's more colloquial and less jargony. So, while the largest NGOs have the budget to rival a country like Haiti or Moldova, a small country, the world's largest corporation by revenue, which is Walmart, has revenues that put it on par with a large country like India or Spain. Multinational corporations play a significant role in lobbying for or against international treaties. For example, fossil fuel companies tended to lobby against climate change treaties, and export-oriented businesses tend to lobby for vast free trade agreements like the WTO and its predecessor, the Global Agreement on General Tariffs and Trade. Now, some NGOs and MNCs even have standing, that is legal recognition, to, for example, bring a case in international courts. NGOs can bring cases in international human rights courts of the Americas or Europe or Africa. And this brings us to an important point about the rights and responsibilities of NGOs, but really mostly about multinationals. Multinational corporations are often able to sue governments for violating their rights under international treaties. So, for example, in 1997, Canada banned the import of the gasoline additive MMT for fear of environmental damage. It's a manganese-based gasoline additive. Ethel, a Virginia-based company, sued them under Chapter 11 of the North American Free Trade Agreement, claiming that the law would damage the company which made MTT additives. In the end, Canada changed the law and paid $13 million in legal fees and damages when it essentially lost this case in international arbitration. Now, in some ways, this is appropriate. These kinds of international investment treaties help protect free trade, which benefits the overall economy and helps prevent economic nationalists favoring their own country's companies at the expense of foreign ones. On the other hand, there are two big problems with this. First, a smallish Virginia-based company is overturning a law created by Canada's democratic government, and Canada's taxpayers are footing the bill. Second, while international law gives corporations a fairly large number of venues in which they can sue governments, there are few international legal venues in which they can be sued. This is in part because these companies can be sued in national courts. So to take a recent example, when the Dutch oil company Shell spilled oil and caused tremendous damage to the environment and livelihoods of fishermen and farmers in Nigeria, their Nigerian subsidiary can be sued. But that subsidiary is only a small part of a larger multinational company, which is really beyond the reach of Nigeria's courts. Now, this is starting to change at least a little bit, as in this case, Nigerians were bringing cases against Shell both in the United Kingdom and in the Netherlands. This, however, is kind of a suboptimal solution. It's a little bit ad hoc because the more obvious venue for this would be some sort of international court. But this, so far, has not been something that's a solution that's arisen. So to summarize, in the current international legal regime, multinationals tend to have more rights than responsibilities. They have significant power to sue countries in international courts, but generally cannot be sued in international courts. Changing this should be an important part of progress in international law as the regime develops further. Thanks so much.